doctrine of foregone conclusion is a very important aspect. But this particular doctrine has not been followed in India. It is specially followed in the case of US and some European countries. So I will take that into consideration whether India also needs to follow certain doctrine.
If in a case the police force me to surrender the knife I killed the victim with, you will say that in that case there is no self-incrimination problem?
You cannot import the US privacy jurisprudence hook, line, and sinker, because there are some other parts that might not help your constitutional privacy, just like Nigeria.
You have to consider whether your eventual solution that you come up with for the Indian approach needs to be consistent with how human rights law has so far been developed in India when it deals with similar situations, but situations that aren't in the digital world.
What specific reasoning would distinguish a memorized alphanumeric password string from a memorized confession?
How does human rights and constitutional law in India deal with search and seizure by the police in relation to, for example, a locked diary or a locked letterbox, or the police going through somebody's rubbish? Because they are also ways of accessing the same kinds of information. So the data is kind of like the information or the intelligence that the police are going after.
But the interesting thing is that at the same time, lower courts are split in the US regarding the question of whether forced decryption, even including by revealing the password, violates the right against self-incrimination or not.
My central argument is saying that compelling an accused to unlock his smartphone violates his right to privacy and right against self-incrimination.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperations.
Global South Network provide a platform for meaningful dialogue and cooperation, fostering efforts to build a more equitable and resilient legal landscape.
GSN network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Ayad, for the immense work that you're doing in the GSN, and the Global South Network is a much admired initiative.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
We are being criticized for doing our job and for upholding the federal constitution. Like I have said in the past, I will not bend to such lame pressures and insinuations.
Dr. Norman Riat, the founder and convener of the Global South Network's visionary leadership has established a vibrant forum where judges, academics, and practitioners from around the world can share and exchange ideas.
I would like to point out that Dr. Riat's initiatives have not only enriched comparative judicial dialogue, have also fostered mutual understanding of the diverse challenges that courts face in safeguarding the rule of law and constitutionalism.
After all, what would you do as a colonizer from the global north, conditioned by a systemic othering mindset and driven by economic lust built on commodification, including the commodification of human beings?
This last question is not so easy, a bit complicated.
The Global South Network provides an important space to share experiences and learn good practices from one another.
Dialogue takes on particular importance thanks to Global South Network, which allow us to believe in a better world of the rule of law.
It is my pleasure to welcome you to the 24th seminar in Phase 5 of our International Interdisciplinary PhD in Progress weekly seminar series organized by the Global South Network. I'm Dr. Norman Riat, lecturer in law at the Leicester Law School and founder and chief convener of the Global South Network, and I've been running these sessions since March 2023. My research interests lie within the areas of constitutionalism, rule of law, judicial independence, and judicialization of politics, mostly in developing democracies. It is a pleasure to be with you all today, and I look forward to what promises to be an engaging and thought-provoking discussion. I'm joined by three discussants from different parts of the world. Dr. Fenella Billing is the first discussant for today's session. Dr. Billing is an associate professor in international law and human rights at Aalborg University, Denmark, where she teaches comparative law, European Union law, and fundamental human rights, as well as international law and international human rights law. Dr. Billing holds a position as adjunct senior researcher with the School of Law, University of Tasmania. Since completing a PhD on the right to silence in transnational criminal proceedings, Dr. Billing's research has focused on transnational law enforcement and human rights, for example, on issues related to hybrid threats, the right to silence, and the principle of mutual trust in the European Union law. She has researched extensively in the intersection between human rights and the law of the sea, including human security at sea, migrant smuggling, and maritime migration. Dr. Olumide Babalola is the second discussant for today's session. Dr. Babalola is the managing partner of Olumide Babalola Law Firm, Nigeria. He holds a PhD from the University of Portsmouth, where his doctoral thesis titled Developing a Nigerian Constitutional Right to Privacy Through the Courts, Comparative Judicial Approaches from South Africa and Kenya, examined the judicial development of constitutional privacy rights through comparative analysis. Dr. Babalola is widely recognized for his expertise in data protection and privacy law. He acted in the landmark Court of Appeal case Digital Rights Lawyers Initiative versus National Identity Management Commission 2021, the first Nigerian Court of Appeal decision on data protection. The ruling became a leading authority and a focal point in legal discussions on data protection in Nigeria since its delivery in September 2021. In addition to his legal practice, Dr. Babalola serves as a faculty member for several certificate awarding data protection training programs, including the University of Lagos Certificate Course in Data Protection, on which he has taught since 2021. Dr. Javier Escobar Villas is the third discussant for today's session. Dr. Villas has a PhD in legal studies from Bocconi University. He has pursued academic teaching and research activities at higher education institutions in Chile, and Europe, focusing primarily on criminal law and procedure, comparative law, human rights, and law and technology. His research has been published in several international and European journals. He is currently a Humboldt Research Fellow at the Max Planck Institute for the Study of Crime, Security, and Law. He has also been a visiting researcher at the University of Madrid, the Max Planck Society, and the University of Barcelona. Last but not the least, our today's guest speaker is Himanshu Mishra, who is a PhD scholar at the National Law University, Delhi. Himanshu's current doctoral research examines the constitutional boundaries of digital search and seizure, privacy, and the right against self-incrimination in an increasingly digitized world. Today, Himanshu will present part of his PhD project titled Search and Seizure of Personal Gadgets, Constitutional Analysis through the Lens of Right to Privacy and Right Against Self-Incrimination. Himanshu, you will have approximately 30 to 35 minutes for your presentation. This will be followed by comments and questions from our discussants, who will each have around 5 minutes. If time permits, we will then open the floor for a 15-minute question and answer session with attendees. Himanshu, thank you for joining us today. The floor is yours.
Good evening, everyone. Good afternoon, everyone. This is Himanshu Mishra. I am currently pursuing my doctorate from National Law University, Delhi. And I am particularly dealing with a topic of my interest, that is search and seizure of personal gadgets, constitutional analysis through the lens of right to privacy and right against self-incrimination. First of all, I have chosen this particular topic because of my interest in the intersection of technology and law. And this is the particular question which is not resolved in any part of the globe. If you talk about US, different states have their own interpretation. If you talk about India, different high courts in the state, they have different interpretation as to whether the police officer or any investigative authority, whether they can compel an accused to unlock his or her smartphone. So if any person, if he is accused of any particular offense and the police officer, they knock at the door of the accused, then can the police officer, can they really compel the accused to unlock his smartphone? Can they compel the person to provide biometric or the password of either mobile phone or the laptop? Can they do that? And will that violate right to privacy and right against self-incrimination? Right now, there is a huge research gap in this particular area. There lies a gray area research gap in this particular domain of law. As I have mentioned, different states, different countries, they have their own laws, they have their own interpretation, and for different offenses, there is different law. Now, briefly introducing the topic, as I mentioned, the central conundrum, primarily we have two fundamental rights at stake. The first one we have is right against self-incrimination. Under Indian Constitution, this is enshrined under Article 20, Clause 3. Whereas in US Constitution, that is given under Fifth Amendment of US Constitution. Now, this right simply mentions that, simply states that you cannot compel an accused to be a witness against himself. So, if I am accused of any particular offense, of any particular crime, then no police officer, no judicial magistrate, no justice, they can compel me to make a statement, to impart knowledge, whether in oral or in writing or any documentary evidence, be it in any physical document or in electronic document, that can be used against me. So this is the simplest meaning of right against self-incrimination. In India, this particular right is only available to the accused, whereas in US and UK, this right is extended to both witness as well as the accused. So in India, the right is confined only to the accused. Now, in the case of MP Sharma versus Satish Chandra, Supreme Court for the very first time in India, they have dealt with the question as to what can be compelled and what cannot be compelled. What statement, whether they should be oral, whether they should be documentary. So in the case of MP Sharma, Supreme Court has mentioned that oral as well as documentary evidence, they both cannot be compelled from the accused. Now, in another landmark case of Supreme Court, the name of the case is State of Bombay versus Kathi Kalu Ogad. In this particular case, this one is a landmark case, 9-judge bench case on the issue of right against self-incrimination. In this particular case, the Supreme Court has indoctrinated the concept of personal knowledge. Anything that is based on your personal knowledge cannot be compelled from you. That information cannot be extracted from you, be it in documents, be it in oral evidence. Now, this doctrine of personal knowledge is very important because this is also akin to the doctrine of independent of will as is used in the case of UK. In UK, in the case of Saunders versus United Kingdom, they have propounded the doctrine of independent of will. Something that exists independent of my will cannot be compelled. Similar to that, Supreme Court in the case of State of Bombay versus Kathikalu Ogad has mentioned about personal knowledge. Now, my handwriting sample, my DNA sample, my voice sample, this is something independent of my will, or this is something not based on my personal knowledge. I am not using my cognitive faculties. I am not using my mental faculties in using all that. In that case, police officer or any investigative authorities, they are allowed to compel evidence that are not based on my personal knowledge. So if any accused is drink and driving, in that particular case, you can take the alcohol test because that thing is again not based on his personal knowledge. If you have to take a fingerprint specimen, in that also particular case, my fingerprints, if they have to match it with the crime scene, then that is for the aspect of comparative aspect. They just want to compare two fingerprints. So there is nothing inherently personal knowledge on that. So Supreme Court has made a very important doctrine that is also a current law of land. And I'll be mentioning this doctrine of personal knowledge extensively and repeatedly throughout my presentation as well as in my thesis. Now, the problem is when the police officer or any investigative authority, when they compel an accused, are they asking anything based on their personal knowledge? So, for example, I have this my phone, and if I tap my if I tap my thumb on it, it will automatically unlock. Now my thumb is also my fingerprint, and this fingerprint impression is unique, and that is not based on my personal knowledge. So does that mean can they forcefully take my fingerprint and put that into my laptop or my phone to unlock my device? Because normally for comparative thing, they can always take my fingerprint sample. But what about the case? What about the case of my mobile phone? So like in India, Supreme Court is in particular silent on this issue. Supreme Court hasn't dealt with this particular issue, but various high courts, they have a chance to deal with this issue. Now, Karnataka High Court and Kerala High Court. Karnataka High Court in the case of Virendra Khanna have mentioned that taking my fingerprint or the password, that is not based on my personal knowledge because there is nothing inherently incriminatory in them. They are merely asking my password. They are merely taking my fingerprint impression. So there is nothing inherently incriminatory in that, and they can compel that from me. This is the reasoning of Karnataka and Kerala High Court. So they have allowed the investigative agencies, the police authorities to compel unlocking of my device and getting all the data from that. Delhi High Court last year, approximately 5 to 6 months back, they have disagreed with the judgment of Karnataka and Kerala High Court, and they have mentioned that you cannot take either biometric or your password to unlock phone because your mobile phone and your laptop, it contains vast plethora of data that can be used against you. The fingerprint and the password you are taking has a functional aspect. So if you are not directly doing that, you are indirectly compelling that particular person. You are indirectly compelling that particular person to disclose all the information, all the data, and every aspect of his life, which he wouldn't have disclosed in a normal circumstances. So something which you cannot do directly, you also cannot do indirectly. You cannot directly ask a person anything that can be used against him in a court of law. Similar to that, you cannot get the password, you cannot get the biometric to unlock the phone. There is also another important aspect. Whenever we study right against self-incrimination, we do that with right to remain silent. Now, right to remain silent does not exist in silo. It has to be read with fundamental right of speech and expression. If I have a right to speech and express myself, then I also have a right to remain silent. That is also an important facet of right to personal liberty, that this is my liberty not to speak anything, and you cannot compel me to speak. So right to remain silent comes under the aegis and the ambit of speech and expression, my personal liberty, and also right against self-incrimination. Supreme Court in the landmark case of Nandini Satpathy versus P.L. Dani, they have mentioned that right to silence is a very important facet, very important aspect of right against self-incrimination. If the police officer, an investigation, any magistrate, they are asking direct question, answer to which can directly incriminate that person, in that case the accused or the suspect has a right to remain silent. And one more important addendum, the neither the magistrate nor police officer, they cannot draw an adverse inference if I am choosing my right to remain silent. They cannot give dictum, they cannot give judgment on the basis that I was silent and because of my silence they have drawn an adverse inference against me. But in this principle is same in US and India, but in UK courts are allowed to draw an adverse inference against an accused if the accused chooses to remain silent. Now, in the case of disclosure of password, in the case of disclosure of password or biometric, in that particular case, you are snatching or infringing the right to remain silent of the accused. If not for my mobile phone, if not for my laptop, I wouldn't have spoken. But you have snatched my mobile phone, you have taken away my laptop, and you have forcefully extracted password or biometric, you have unlocked my device. So my right to remain silent has infringed, thereby directly affecting my right against self-incrimination. This is the central argument of my thesis. Now, another important aspect, I have mentioned about right to privacy. I have mentioned about right against self-incrimination. Now, coming to right to privacy, so initially during the inception of the constitution, there were no cases which have drawn the relationship between right against self-incrimination and right to privacy. Supreme Court in 2014 in the case of Selvi versus State of Karnataka. This case I am using extensively, Selvi versus State of Karnataka. In this case, in the case of India, in the case of Indian jurisprudence, for the very first time, Supreme Court has drawn a very important symbiotic nexus between right to privacy and right against self-incrimination. And they have mentioned that when you are forcefully extracting information, you are not just violating right against self-incrimination, you are also violating his right to privacy. And another notable thing about this judgment is this judgment came before the case of K.S. Puttaswamy, which came in 2017. So before the case of K.S. Puttaswamy, in the case of K.S. Puttaswamy, Supreme Court held that right to privacy is your fundamental right. That is implicit under Article 21 of Indian Constitution, your personal liberty. If you have to enjoy your personal liberty, then you must have privacy. Without privacy, you won't be able to enjoy your personal liberty. Now before that, even before reading, interpreting right to privacy as a fundamental right, Supreme Court in the case of Selvi has held that there is a symbiotic nexus that lies between privacy and self-incrimination. Now the facts of this case, they are very interesting, and they deal with narco analysis test. In narco analysis test, what is being done is, any investigation authority, they inject sodium pentothal. By injecting sodium pentothal, the accused goes in a subconscious state, and in that subconscious state, the police officer or the authorities, they continuously ask questions. Now the accused is not aware that he is voluntarily giving answers to that question, but in narco analysis, the accused is forced to answer all those questions, and accused is not mentally aware of that. This is kind of involuntarily thing. Supreme Court in the case of Selvi has held the practice of narco analysis to be unconstitutional, because that violates the right to privacy as well as right against self-incrimination. Your right to silence is being affected, your right to privacy is being affected. Whatever question has been asked, you have no choice. You are not in an aware state whether to answer to that question or not. You are forced to answer to that question. The Supreme Court has drawn a very important, very symbiotic relation between right to privacy and self-incrimination. Your informational privacy, your cognitive faculties. Because in narco analysis, they also ask questions that is based on your personal knowledge. And you do not have any active choice. You do not have a choice to remain silent because you are not conscious. So I am using this ratio decidendi of the case of Selvi in my thesis to strengthen my core argument that similar to narco analysis, there exists a relation between right to privacy and right against self-incrimination in the case of mobile phone and in the case of laptop. So likewise, the information, the data contained in your mobile phone, that is based on your personal knowledge, that is based on your cognitive faculties, your informational privacy. That is very, very important thing, and you cannot forcefully extract from that. So in the case of KS Puttaswamy in 2017, Supreme Court finally declared right to privacy as a fundamental right. And it was declared that Article 20 Clause 3 and Article 21 cannot be read in silo. They have to read together. And using that ratio, using that dictum, we can simply state that if any police officer or any investigative authority, if they are compelling any person, then that violates right to privacy, right to remain silent, personal liberty, and right against self-incrimination. Now, there is a very important Supreme Court judgment of US Supreme Court, Riley versus State of California. In the case of Riley versus State of California, Supreme Court has mentioned that our laws, our regulations, they are obsolete. They are made for physical drawer with respect to search and seizure. That they are made for physical drawer. They are made for physical documents. You cannot apply that doctrine, that concept, that rules and regulation to the case of digital device. These devices, they mandate, they warrant a new set of rules and regulation. You cannot rely on obsolete and outdated laws because they have far more complications. Because a document contains a limited information, but if you talk about mobile phone, that has plethora, unfettered information, and if that goes in wrong hands, that can be misused. So Riley versus State of California is a very, very important judgment, and Supreme Court in this case has held that the investigative authorities cannot compel a person to be a witness against himself. If you talk about, like in my first chapter, I am talking about introduction. In my second chapter, I am talking about right against self-incrimination. In my third chapter, I am talking about a relationship that exists between right against self-incrimination and right to privacy. And in my chapter 4, I'll be talking about search and seizure power of the police officer. As to what extent the power of investigative agencies or police officer lies. So whether magistrate in India or any part of the globe, can they issue a warrant? Can they issue a warrant compelling an accused to unlock his mobile phone or laptop and give it to the police officer? Now, this particular thing or this particular inadvertent error has been committed by Supreme Court in the case of Saket Modi. In the case of Saket Modi, the case is related to prevention of money laundering. In that particular case, Supreme Court has imposed this as a bail condition, that if you have to get a bail, then you have to give police officer access to your mobile phone and your laptop. Now, this is a question of constitutional interpretation, whether you can impose anything as a bail condition that violates your constitutional right. But Supreme Court and High Court, they have done this in multiple cases without focusing on right against self-incrimination and right to privacy. Now, talking about search and seizure power of police officer. Now, the US Fourth Amendment, the Fourth Amendment of US Constitution, it talks about, it prohibits unreasonable, unwarranted search and seizure power of any police officer or any investigated authority. That there is a limit to your search and seizure power, and you cannot extend your search and seizure power to violate any fundamental right or constitutional right of an accused or a suspect. Now, in India, our constitution is silent on this particular aspect. We are governed by Bharatiya Nagarik Suraksha Sanhita, in short BNSS. Now, BNSS has recently replaced old criminal law, that was Criminal Procedure Code, in 24. From 24, we are using this new particular legislation, that is your BNSS. Now, even BNSS, despite being enacted in a digital era, is silent on this particular aspect. But even BNSS does not authorize any police officer or any magistrate to compel an accused to unlock his mobile phone or password. Now, in the aspect of search and seizure, there also lies an important distinction between due process model and a crime control model. Now, this model, the names of this model, the theory of this model, they were formulated by a notable constitutional scholar named Herbert Packer. Herbert Packer, in his two models of justice system, has talked about due process and a crime control model. Now, talking about crime control model, as the name suggests, the main objective, the main rationale of crime control model is to prevent or to prohibit crime. Now, if the police officer or the state, if they have this aim or if they have this rationale of preventing any particular crime, in that particular case, they won't be having any issue in infringement of your fundamental right, because their main aim is prevention of crime. But in the case of due process model, their main aim and their main objective is also to make sure no rights, no human rights, no fundamental rights, no legal rights, they were to be violated for the sake of resolving any investigation. So in due course model, they focus on your fundamental rights, whereas in crime control model, their main focus is on preventing the crime. So in crime control model, they are allowed to infringe on fundamental rights, whereas in due process model, they have to take care of a fundamental right. Now, in a very landmark case of Menaka Gandhi versus Union of India that came in 1975, in that particular landmark case, Supreme Court has held that, Supreme Court has observed that your Article 21, your right to life and personal liberty, it cannot be infringed except due process followed by the state or the government. If they have to violate your personal liberty, then they have to mandatorily follow your fundamental rights and your human rights. So after the case of Menaka Gandhi, we have been following due process model. Now, applying that due process model, we can simply state that When any police officer is compelling any accused or any suspect to unlock his mobile phone or digital device, in that case, they have to mandatorily follow fundamental right or the basic human rights. Neither magistrate nor any judge, they cannot compel any accused person to unlock his mobile phone or digital device because we are living in an era of due process model. Now, briefly talking about comparative aspect, in comparative aspect, I have studied laws of US and UK. Even though US has a very strong framework in case of fundamental rights, there are certain number of cases which are in favor of compelling an accused to unlock mobile phone. Multiple or more number of cases they are in favor of not compelling an accused because that violates fourth constitutional amendment that talks about search and seizure, fifth constitutional amendment that talks about right against self-incrimination, 14th constitutional amendment that talks about due process model. So in US, there is confusion with respect to compelling or not compelling. But in UK, the law is kind of straightforward, kind of clear, that is in favor of compelling an accused to unlock his smartphone. Now, there is this particular legislation in USA that is Regulation of Investigation Powers Act, REPA Act. REPA Act allows investigative agencies to compel any individual, any suspect or any witness to unlock his smartphone or laptop. Failure of doing that will result in imprisonment or incarceration up to 2 to 5 years. So in UK, they are kind of following a crime control model, whereas in US, they are oscillating between crime control and due process model. So concluding my topic quickly, central argument of my thesis is that if you are compelling an accused to unlock his mobile phone or laptop, you are retrieving, you are gathering large amount of data, gargantuan amount of data that violates accused right to privacy, right against self-incrimination, personal liberty, and right to remain silent. There is a symbiotic relation that exists between right to privacy and right against self-incrimination, which makes my central argument stronger. And also, post the case of Menka Gandhi and this post-modernist era, we have been following due process model. In due process model, we cannot easily infringe fundamental rights of any particular individual. Thank you, sir.
Thank you very much, Himanshu, for a very engaging and thought-provoking presentation. On behalf of everyone attending today's seminar, I would like to thank you for sharing this fascinating part of your doctoral research with us. You have addressed a highly contemporary constitutional question at the intersection of privacy, criminal procedure, and digital technology, and have highlighted an important gap in Indian law following BNSS 2023, particularly concerning compelled access to digital devices and its implications for the right to privacy and against self-incrimination. One aspect that I found particularly interesting was your argument that the contents of a personal digital device should be understood as an extension of an individual's personal knowledge, inviting us to rethink traditional constitutional doctrines in light of the realities of the digital age. I will stop myself from discussing your paper because I'm just cheering. I do not want to abuse my position. It's now my pleasure to invite our first discussant, Dr. Fenella Billing, to offer her comments and reflection on Himanshu's presentation. Dr. Billing, the floor is yours.
Thank you. Thank you, Naman. And I would like to reiterate, Himanshu, congratulations for a really interesting topic, and it's very relevant to technology and law. We have to put some of these, question some of our principles that we have already developed in the technology and law context. And you've done a really great presentation, and it's a very good topic. So I've got 3 comments, and I'll start straight away with the first. And this is about, and it probably follows on a little bit from what Naman has just said, but it is about challenging your approach to those main arguments. So in your I've had the benefit of reading an abstract. So in the abstract, you talk about a personal device being a direct extension of an individual's personal knowledge, and also in your preliminary findings that smartphones contain this endless amount of intimate data, which requires a unique approach to regulating them. And so I suppose my comment goes into how do passcodes fit into this categorization of personal knowledge and this categorization of what is intimate data. And I want you to ask yourself and potentially ask your readers, to what extent do these arguments call for a unique human rights approach? And I'm thinking, shouldn't we really focus on the data itself and whether that is something that is within the mind of the accused, rather than focusing on the key to get to the data, because it's really the data and the evidentiary value of the data that we need to protect the accused from being forced to reveal. So I'm not going to conclude on that question. It's just something that I'm raising, that you need to maybe be very clear about your approach to what the relationship is between passcodes and the actual data that the police are trying to seek. And the second comment goes to this, further to this need for special regulation. So your starting point is that mobile devices or laptops, for example, are more than just communication tools, and that they are these repositories of our complete digital lives. And I want to challenge this just to open up the discussion from the human rights perspective. And maybe you have to consider whether your eventual solution that you come up with for the Indian approach needs to be consistent with how human rights law has so far been developed in India when it deals with similar situations, but situations that aren't in the digital world. So, for example, smartphones can contain correspondence, they might contain banking records, they can contain emails and communication, they can contain photos, they might even contain intimate notes on a smartphone. So a smartphone contains a range of different kinds of information, but some of these types of information have actually possibly already been dealt with by human rights law in India, for example, correspondence. So I've got two main questions. How does human rights and constitutional law in India deal with search and seizure by the police in relation to, for example, a locked diary or a locked letterbox, or the police going through somebody's rubbish? Because they are also ways of accessing the same kinds of information. So the data is kind of like the information or the intelligence that the police are going after. And this could be in a digital form, but it can also be exactly the same information that comes in a more physical form. So how has Indian law already dealt with those more physical types of situations that can be analogous to what is contained on the smartphone? And the second question is, for example, how does a fingerprint at a crime scene, how does that compare to a digital footprint? So again, we're looking at it's the intelligence that it gives the police that is perhaps what needs to be in focus. And I say perhaps because this is, as I said, it's just, I'm raising some points that you can maybe question for yourself. And I suppose these questions also go a little bit to your structure, because maybe what I was missing a little bit is a comprehensive background. And I would say, firstly, to the search and seizure regulation in India, and then secondly, a comprehensive background to the fundamental rights that are at stake. So right to privacy and right against self-incrimination, where you develop a knowledge of these rights in these other kinds of analogous situations, so that you can then inform your decision about how do you treat information that's contained on a smartphone and what should be the human rights approach to that. My third comment is about your comparative methodology and sources of law, because I mean, obviously the choices in relation to sources of law is very relevant when you're doing something comparative. And perhaps you need to consider placing the actual regulation in the US and England in a human rights perspective. So there might be some human rights frameworks that are also talking into the regulation of the police requiring passcodes. For example, in England, the Human Rights Act of 1993 will sort of, in a way, implements the European Convention on Human Rights into the English legal system. So perhaps you need to also consider what is the European Convention on Human Rights and what is the European Court of Human Rights saying about these types of issues, because there is actually quite a relevant case from the European Court of Human Rights of Sabah and Norway, and the judgment was in 2020, where a smartphone was seized and they accessed information on that smartphone. But what was at issue was the fact that some of this information was actually covered by a legal professional privilege. So that was really the issue that was at stake. But the court actually dealt with this under Article 8 of the Convention, which is the right to privacy. So they didn't go into the right against self-incrimination. And if you look at the convention law in general, these types of, they do make a distinction between how you access information, and sometimes that is often dealt with under other rights, such as the right to privacy, and then the evidence, and the evidence being used in a trial or in criminal proceedings, where they then go into Article 6 and the right against self-incrimination. So there might be a distinction there that certainly when you're talking about the English law, you need to make that distinction and maybe inform not only the actual regulation and the case law in England, but also the background human rights framework, which is the European Convention. So I'll leave it at that, because I've probably gone longer than my allocated time. So, sorry.
4 minutes of Bob. But fine, no, it's fine. I think it was very useful. Just first, let me see recording. All right, okay. Thank you very much, Fenella, for your thoughtful and insightful comments. We're grateful for your careful engagement with Himanshu's work, observations on constitutional dimension of digital privacy, the comparative perspective, especially with the Human Rights Act and the European Convention, and the broader implication of this research have provided valuable feedback that I'm sure Himanshu will find extremely useful as he continues to develop this project. And I also hope he is taking notes, because in the end, I will give you opportunity to respond to these comments if you wish to do so. It is now my pleasure to invite our second discussant, Dr. Olumide Babalola, to offer his comments and reflections. As a leading practitioner and scholar in data protection and privacy law, Dr. Babalola brings a wealth of expertise to this discussion, and I'm sure his observations will further enrich the ongoing discussion. Dr. Babalola, the floor is yours.
Thank you very much, Dr. Neumann, for the invitation. Thank you. And also to the speaker, to the guest speaker, Himan. Trust me, when I saw the topic that you are researching, it's extremely hooked. First of all, it is very novel and it is thought-provoking. I have to also take out time to also do a little bit of research on what you're doing because it is extremely, I mean, Nigeria is it's totally blank on that. Nigerian courts have not even taken any decision whatsoever. It's an interesting one because, just like you said, it's an intersection of technology and law. It's a very interesting one. And just like Dr. Billing has made some comments, you would have a whole lot of work to do around this. That is the price or the either the benefit or detriment of conducting research in an area that is not so explored. So my intervention would just be so you have also identified that the High Court in Karnataka equated password to a physical key, and well, some CBI special courts have treated it differently as testimonial, and I think you would have to interrogate what specific reasoning would distinguish a memorized alphanumeric password string from a memorized confession. So in this case, there has been various arguments or even some decisions that equated password with a physical key, even though you might really want to interrogate that if we can possibly equate an electronic information, or if we can equate an information to a physical structure. You might want to give some deep thought into that, and how you want to distinguish that, because passwords would always have numbers, would have digits, would have special character, and how you will equate that to some facts about the case which someone has possibly memorized. So you also want to interrogate whether the analogy of a key that exists in an accused person's mind and nowhere else. Most likely, facts in a criminal matter, most likely, would be something that also exists in some other person's either mind or for events that occurred in the private, but they were actually facts that occurred. But in the case of passwords, sometimes these are creations of the subject. And also another thing you might also want to interrogate very well is identifying that passwords are personal data, whether created by someone, whether reproduced by the accused person, they constitute the accused person's personal. So except you want to specifically limit your intervention to privacy. And even if you want to do that, personal data could also equate to private facts. So these are things you might want to really look at. Now, on the foregone conclusion doctrine, you might want to interrogate how the US exception would apply in the Indian context for many reasons. Because Article 23 that you have interrogated does not have an equivalent of the foregone conclusion. Now, the question you want to ask yourself, or the question you want your readers to be able to see whether you have answered, is whether when you import that foregone conclusion doctrine, which is a foreign doctrine, whether you will import it as a judicial innovation, or whether it will dilute the standard that you already have in India, the standard of that mental privacy. You might also want to look at it, whether they can coexist, or whether if you advise an importation of that US doctrine, whether it will dilute what you already have in India, or if it will improve it as an innovation. You know, I have always thought, also argued in some cases that whereas the US Fourth Amendment might provide some springboard or some foundation or some persuasive authority for how privacy should be viewed in some other jurisdictions, the argument I've also made is that you cannot import the US privacy jurisprudence hook, line, and sinker, because there are some other parts that might not help your constitutional privacy, just like Nigeria. US mostly views privacy as a tort. So if you import it hook, line, and sinker, it will affect your argument around constitutional privacy. The third question I'd like you to look will be your proportionality test, whether the blanket seizure and the cloning often fails. So you want to look at it in practice from a practice perspective, and how investigators would identify the relevant data. And I think Dr. Billing also mentioned that on a device, without first cloning or accessing the entire device itself. Dr. Billing said it, device contains many other data, many other information. Now, interrogate whether the proportionality requirement will create a practical paradox or baseline for digital search. Once again, thank you very much for this extremely innovative and thought-provoking research.
Thank you very much, Dr. Babalola, for your insightful comments. We are extremely grateful for your expert reflections, particularly from the perspective of data protection and privacy law. Your observations have added an important practical and comparative dimension to today's discussion and will, I am sure, provide Himanshu with valuable guidance as he develops this research further. So Himanshu, you have got the kind of European perspective. Now you also received some kind of a African comparison of African perspective with the American perspective, because you might not be aware, but Dr. Babalola PhD was focused on privacy law with special reference to the comparison of South Africa and Kenya. And now, it is now my great pleasure to invite our third discussant, Dr. Javier Escobar-Villas, to offer his comments and reflections. Dr. Escobar-Villas brings extensive expertise in comparative constitutionalism, and I'm sure his perspective will further enrich our discussion. Dr. Escobar-Villas, the floor is yours.
Thank you very much. I would like to ask some direct questions, and I would like to ask the candidate to answer them immediately, because I just want to know whether I got the point. So, for example, are you proposing what you're proposing would only apply to digital devices that have enormous amounts of personal information, right?
Yes, sir.
Okay. So that's what I thought that I understood. So therefore, for example, you would say that if in a case the police force me to surrender the knife I killed the victim with, you would say that in that case there is no self-incrimination problem?
Sir, the knife exists independent of the will of the accused, or the knife is not something based on the personal knowledge. So, if the
Yeah.
accused has to surrender the knife, then that is not based on her cognitive faculties. But the
And then
data contained
if the police force me to unlock a digital device that does not have enormous amount of personal information because I just bought a cell phone to perform my criminal activities, but I have no other personal information, like no messages, no picture. I just sell drugs with that phone. You would say that in that case, there is no problem from your perspective?
So from my perspective, if I'm selling drugs by using that particular mobile phone, then that phone contains call records of the accused, and the call records can be used against that particular accused, and the police cannot compel password from that mobile phone. So it is not sine qua non, it is not compulsory that the phone must contain enormous amount of data. Even a tiny statement, a tiny call record can amount to self-incriminatory statement.
Okay, but okay, okay. So now my comment is the following: that I am not sure whether I see that what you are trying to do is to apply the traditional approach to a new reality that we have, and this is a very personal opinion. So I'm not saying that this is the right one, but I would say that trying to force the traditional approach is not convincing completely, at least not to me. And because I struggle very much to see that putting my finger on a phone that only has 5 records, and they are all about criminal activities, therefore no, let's say, no private information in a strictus sensus. I struggle to see how that poses a problem, and for you it does not pose any problem if I put the same finger in order to be identified, or if the police ask me to surrender the knife I killed the victim with, which has my fingerprintings, etc. I mean, if I had to choose, I would rather unlock my phone than surrender the knife. And I think that, and I just say this not trying to convince, but just trying to show a different way in which I think that we should solve the thing. I think that maybe the traditional approach should be abandoned, and the distinction between testimonial evidence that you define as that involves expressing my knowledge about a circumstance of fact, I assume, and non-testimonial evidence. I'm afraid that the whole problem about self-incrimination is related to that, to the traditional interpretation that is not imposed by current law. Obviously, we can discuss this. Obviously, we can discuss this because then, for example, I even if I follow your approach, then my first critical comment would be that maybe I miss it, but I didn't hear, at least not clearly, like the rationale of the underlying rationale when we talk about self-incrimination. So, for example, like why do we have this right? Because like that distinction can only be made if we previously discuss about the rationale. But because, for example, like in the US, it's quite clear. Like one can certainly criticize the US case law, but US courts, they say, look, this is limited to testimonial evidence because the rationale is like to prevent the defendant from like being compelled to share with the government the view, beliefs, and or like they also say knowledge. But the interesting thing is that at the same time, lower courts are split in the US regarding the question of whether forced decryption, even including by revealing the password, violates the right against self-incrimination or not. And I think that there you see that the discussion is connected to the rationale, because they say if we do not want to force the defendant to share like their knowledge, the foregone conclusion doctrine is a mandatory consequence, because if the government already knows that that cell phone is mine, by decrypting the phone, I'm not communicating the government anything new. Yeah, but the problem is that when the government finds the phone in my power or at my house, it is more than reasonable to believe that this phone is mine. So the foregone conclusion doctrine, as a consequence of the testimonial component, has limited severely the scope of application in this kind of cases. So I just drop that thought there, that I understand the effort, like taking as a starting point the Supreme Court approach, but I would just propose to wonder whether it is better to also criticize the landmark decision, because maybe the landmark decision was not necessary. Thank you very much.
Thank you, Dr. Javier, for your comments. Himanshu, before I hand over the floor to you to respond to these comments, just to make sure ensure that if everybody has got equal opportunity to ask question and participate, anyone from the attendees want to ask any questions, comments, or anything you want to add for Himanshu, so that they can respond to your questions collectively? All right. Okay. No raise of hands, nothing, no comment. Himanshu, the ball is in your court. You do not need to answer all questions, and it is certainly not a viva, so don't feel any pressure. We are here to support you. We are just here to understand, you see, and that's the whole point, bringing together different people from different parts of the world, so you have different geographic and interdisciplinary perspectives. So please, go ahead. Over to you.
Yes, sir. So, like, I agree with the comments made by Fenella ma'am, Escobar ma'am, Babalola sir, that there are certain things, certain aspects they have to look in. Like in my thesis, I mentioned about doctrine of foregone conclusion, but because of paucity of time, I cannot mention that in my presentation. Doctrine of foregone conclusion is a very important aspect. But this particular doctrine has not been followed in India. It is specially followed in the case of US and some European countries. So I will take that into consideration, whether India also needs to follow certain doctrine. Now, another thing with respect to traditional interpretation, like I mentioned in my thesis and my presentation, even US Supreme Court in the case of Riley versus State of California, they mentioned that our laws and regulations, they are obsolete, outdated, and they treat physical cabinet, physical drawer, physical files akin to or similar to our digital device and laptop. So we definitely need new rules, new regulation for data protection to look at this specific aspect. Like in India, they have recently replaced CRPC, which is an older criminal procedure code, and now we have BNSS, Bharatiya Nagrik Suraksha Samhita. Even though India had the opportunity, but they haven't mentioned anything about this particular aspect of compelling any accused to unlock phone. Still, we have to rely on older doctrine, older technique, older concepts to resolve this particular dilemma. And even following the traditional doctrine, traditional concepts, my central argument is saying that compelling an accused to unlock his smartphone violates his right to privacy and right against self-incrimination. And of course, I'll try to, like, whatever argument I'm making, I'll try to make sure I support that argument with any human right rules and regulation, because this is also an issue of human rights, as it involves interplay of many fundamental rights, like I mentioned, right to remain silent, right against self-incrimination. um, for example, in the case of Selvi versus State of Karnataka, Supreme Court has mentioned that Supreme Court of India, that narco analysis is an unconstitutional. Supreme Court of US has also made a dictum that narco analysis is an unconstitutional test, as it violates your basic human rights. So I will take that suggestion, that feedback into consideration, and make sure I support all my arguments with the human rights rules and regulation.
Great. Thank you. Thank you, Mashu, for your response. Allow me to check again with attendees if they have any questions. We are already 10 minutes late, but just to ensure that everyone get an equal opportunity to participate. Thank you very much, Dr. Billing, Dr. Babalola, Dr. Escobar Vias, for your thoughtful comments. I learned a lot, and I think it added to the discussion. It's a very important discussion, very timely, given whatever is going on across the world in the area of criminal law. We do not need to go into the details, but yes, it's very important to protect the rights discussed by Himanshu. Thank you, Himanshu, for your presentation. And we wish you best of luck with the project. In case you want to continue the discussion, you now have the details of experts. You can always reach out to them. I think that's the beauty of the network. We yes, connect to you people. All right, great. Thank you very much. Anyone, any PhD students, any scholars from any part of the world in any area of study, if they are interested in presenting during this series or want to take part as in capacity of discussant or peer commentators, please feel free to get in touch with me at the email leicgsn@gmail.com. Same time next week, let's meet our next guest speaker, the details of which will be communicated to you through emails. Until then, look after yourself. Have a great day. Bye-bye.